Good day, and thank you for watching. If you are renting a property in California based mostly or entirely on a verbal agreement, there is one thing you need to understand immediately. Verbal agreements can create serious problems when disputes arise, because when there is no clear written lease, the biggest question often becomes, what exactly was agreed to? And that question can affect rent, repairs, move out terms, deposits, occupancy, and even eviction disputes. Let's start with the basics. In California, verbal rental agreements can exist. Not every tenancy requires a lengthy written lease to create legal obligations, but the absence of written terms often creates uncertainty. Now, here's the key. When disputes happen, written agreements create clarity. Without that clarity, both sides may remember conversations very differently. Now, here's where many tenants make a mistake. They rely completely on trust, a friend, a family member, a casual arrangement. And because everything feels informal, nothing gets documented. But informal arrangements can become formal legal disputes very quickly. Now, let's talk about rent. One of the biggest disputes involving verbal agreements is the amount of rent and payment expectations. Was rent due on the first? Was there a grace period? Were utilities included? Were partial payments accepted? Without written terms, these questions become much harder to resolve. Now let's discuss another issue, security deposits. Many verbal rental situations involve cash payments with little documentation. And later, disputes arise about how much was paid, whether deposits existed, and whether deductions were proper. Now let's talk about repairs. Who agreed to handle maintenance? What repairs were promised? Were conditions discussed before move-in? Again, without written documentation, proving those conversations later can become difficult. Now, here's another important point. Some tenants assume that because there is no written lease, they have no rights. That is not necessarily true. Legal protections may still apply depending on the tenancy and circumstances. Now, let's discuss occupancy issues. Verbal rental situations often become complicated when additional people move in. Boyfriends, girlfriends, relatives, friends. And because there are no written occupancy terms, disagreements escalate quickly. Now let's talk about move-out disputes. One side may believe proper notice was given. The other side disagrees. And suddenly there are arguments about unpaid rent, abandoned property, or remaining obligations. Now let's discuss another common misunderstanding. Some tenants believe verbal agreements are impossible to enforce, but courts may still examine conduct, payment history, messages, witnesses, and surrounding circumstances to determine what likely existed. Now let's talk about evidence. Even without a written lease, evidence still exists. Text messages, emails, Venmo or bank payments, receipts, witnesses, photos. All of these may later help establish the terms of the arrangement. Now let's discuss another issue, changing terms. In verbal agreements, people often casually change arrangements over time. Rent increases, parking rules, pet agreements, guest policies, but without documentation, it becomes difficult to track what actually changed and when. Now, here's where many people make another mistake. They avoid written agreements because they think it keeps things simple, but unclear arrangements often create the exact opposite: confusion, conflict, and legal disputes. Now, let's talk about retaliation and conflict. When relationships deteriorate in verbal rental arrangements, disputes often become deeply personal, especially when the arrangement involves family members or close friends. And emotional conflict can make communication break down completely. Now, let's discuss another issue, evictions. Some tenants believe that without a written lease, they cannot be evicted, but tenancy rights and eviction procedures may still apply even in verbal rental situations. Now, let's talk about documentation again. One of the strongest protections in any housing arrangement is written communication. Clear messages, receipts, records of payments, move in photos, repair requests, because organized documentation helps reduce uncertainty later. Now, let's discuss another important point: month to month tenancies. Many verbal agreements effectively become month to month rental arrangements, and those arrangements still involve rights and obligations under California law. Now, let's talk about emotional realities. Housing disputes involving verbal agreements often feel personal because trust was involved from the beginning. People feel betrayed, misunderstood, or taken advantage of. And that emotional component often intensifies the dispute. Now, let's discuss another misconception. Some people believe verbal agreements are fine, as long as everyone gets along. But legal protection matters most when people stop getting along. That is when clarity becomes critical. Now let's talk about prevention. Even simple written agreements can reduce major problems later. The rent amount, due date, deposit, occupants, utilities, basic expectations. Those details matter. Now let's look at the bigger picture. Verbal rental agreements create uncertainty because housing relationships involve money, privacy, obligations, and long-term living arrangements. And uncertainty often leads to conflict. Finally, let's talk about expectations. Not every verbal rental agreement leads to problems, but when disputes arise, lack of written documentation can make resolution much harder for everyone involved. Understanding that risk early can help tenants protect themselves. In conclusion, verbal rental agreements in California may still create legal rights and obligations, but they also create major risks when disputes arise. Clear communication, documentation, and written agreements can significantly reduce confusion and conflict later. If you are involved in a rental dispute involving verbal agreements, payment issues, or housing conflicts, understanding your rights and responsibilities is extremely important. Call us at 888 888 6582. I'm Vince Davis, and we are all in this together.